Good morning, everyone. Happy Monday. My name is Gale Schwartz. I'm with the Housing Alliance of Pennsylvania. I'm going to be the moderator for your panel today. I am joined by Rachel Garland from Community Legal Services, Megan Stanley from the Commission on Human Relations for the City of Pittsburgh, and Elizabeth Rios with, from Lansing Legal Services. Is that what it is?
Legal Services of South Central Michigan Lansing office. Thank you.
Yes. So before we get started into hearing some amazing examples of eviction diversion programs, I just want to do some quick level setting for all the folks on the phone, giving you some background, like what is this non-lawyer doing on this panel at a legal services workshop with these great programs. So for those who may not know, the Housing Alliance is a statewide nonprofit membership organization really dedicated to increasing access to safe and affordable homes for all Pennsylvanians. The diversity of our membership really provides us a unique perspective on a range of housing issues, including eviction. Our membership includes low-income renters, organizations that serve low-income renters, organizations that serve people who experience homelessness, housing developers, housing authorities, and local governments. At the end of the day, eviction is a negative outcome for everyone. It is negative for tenants, it is a negative for landlords, and for communities as a whole. For tenants, a far too high percentage of low-income households are getting caught in this cycle of housing instability, unaffordable rent, and poor housing conditions that are unsafe, especially for children. Furthermore, eviction disproportionately impacts women, children, and people of color. Matthew Desmond, the author of the book Evicted, said if incarceration has come to define the lives of men from impoverished Black neighborhoods, eviction is shaping the lives of women. Poor Black men were locked up, poor Black women were locked out. Eviction isn't just a byproduct of poverty, but is a driver of it. For landlords, this is also a huge challenge for them. For many landlords, they are operating on tight margins and are small businesses that are vulnerable to even small disruptions in income. Particularly small landlords are truly a critical source of naturally occurring affordable housing, with mom and pop shops making up 76% of all single family home rental properties, as well as 77% of all small rental buildings with less than 5 rental units. This is also the piece of the market that really does serve the lowest income households as far as tenants. So what we're seeing is that both owners and occupants of small multi-unit buildings with 2 to 4 units really tend to earn less than their counterparts in single-family homes and larger multi-family buildings, meaning that the most vulnerable tenants are more likely to be housed by the most financially vulnerable landlords, further exacerbating some of the tension that happens between the two. And then, of course, eviction is not limited to landlords and tenants. It really does send ripples through the entire community, with costs borne by local governments, schools, employers, hospitals, emergency shelters, financial assistance programs, the courts, and more. So when looking at some comparable cities, when looking at a comparable city to, say, Pittsburgh, if we look to our neighbor to the west, Columbus, what we're seeing is, in research conducted by the Urban Institute, that city government is paying anywhere between $17 and $39 million annually due to evictions faced by families. When looking at a larger city, saying Chicago as, kind of a comparison to Philadelphia, Chicago is paying anywhere from $68 to $157 million annually in supporting families that are facing evictions. So really, we're just seeing costs borne by so many different people, and nobody's really benefiting from this process. So At the end of the day, neither the tenant nor the landlord ever wins when there is an eviction. An eviction is a huge problem everywhere. It's definitely a huge problem in Pennsylvania. Prior to the pandemic, in 2019, there was nearly 99,000 eviction filings in Pennsylvania. And now, to further exacerbate the crisis, we are in a pandemic, a global crisis. And really, all warning signs are pointing to an eviction tsunami. We have seen people go months without paying rent, and this is a crisis for both the tenant and a crisis for both the landlord, as the financial obligations of both are still there. Nothing has been suspended in that respect. Even with moratoriums going back and forth, people are still responsible for their financial obligations. So now another thing that we need to take notice of is that half of low-income renters really do work in the industries that have been hardest hit by unemployment as a result of the pandemic. And, you know, COVID-19 is still there. It's not going anywhere. We're still having more cases every day. And this really has led to great uncertainty when the economy will begin to truly recover. This has disproportionately impacted low-wage workers, therefore the renters and their landlords. Once the economy does begin to recover, we do know that jobs are simply not going to return at the rate in which they were lost. It's going to take a lot longer to open up the economy than it took to shut it down. This all puts far too many households at risk of eviction and homelessness. For the Housing Alliance, along with so many other organizations, we are working to continue to expand the resources and programs that are needed to avoid preventable evictions, including more rental assistance, as well as more access to legal support and expanding mediation programs. What we have been doing at the Housing Alliance specifically, along with partners across the state, is continuing to advocate for statewide rental assistance, advocating for some changes to the current statewide rental assistance program, so it is a little bit more user-friendly for both tenants and landlords. And we are also working with many communities across Pennsylvania to expand mediation programs. Specifically, what we've been able to do is we created and released late last month is a landlord-tenant mediation toolkit, and have been able to provide modest grants through financial support from Regional Housing Legal Services to 5 communities to help them get mediation programs up and running. So I just want to share my screen for a second and go over. There we go. So what we have here, and this is just the executive summary of the toolkit, is, you know, again, as communities are looking at eviction prevention strategies and those who are looking to start with a landlord-tenant mediation program, these are tools that are ready to go to help you save time, save resources, to get the right stakeholders around the table and get the conversation started. So we really see it as, you know, again, and this is true for any eviction prevention model. It doesn't necessarily have to be mediation specifically, even though that is the focus of this toolkit, is, you know, you got to convene the right stakeholders around the table. You've got to educate people and do a lot of level setting about what your model is and how it works. Then you have to design the model so that it meets your community's needs and capacity. And then you have to get the word out. So again, some of this stuff can translate to other programs. Some of it is very, very specific mediation focused, but really starting with the goal of eviction prevention is, who are all of the stakeholders that you need around the table, all of the stakeholders that, the models that are going to be presented today had to bring along with them to get something like this up and running. Because as we stated earlier, eviction is a problem that affects almost every aspect of the community. These are models of existing, again, these are voluntary mediation programs, looking at what's happening across the state as well as across the country. Again, sort of some level setting around resources, designing a program, making sure that you have clear, important role considerations, what piece is responsible for what. But again, I think in any eviction prevention program, no matter what model that you choose, whether it's court-based, community-based, post-filing, pre-filing, you really want to have clear expectations on roles. You really want to make sure that there are good wraparound supports for the tenant and for the landlord in the event that there is something going on with them that they do need some support for. And of course, high quality legal advice and counsel when needed. And then, getting the word out. Many great programs can stumble if people don't know that they're out there. So I will happily put this information in the chat so people can look at it later. But I think, the other thing that we really want to, or that I really want to highlight is that, when it comes to eviction prevention models and strategies, there's many different out there. I don't think it should ever be thought of as an either or, but a both and. It's going to take a lot of different strategies and a lot of different models and programs to really make a huge dent in this eviction crisis. And everything that I've learned about mediation or eviction prevention programs is that they often very, very naturally dovetail and build off of one another. So as whatever place that you start, whether it's a court-based, right to counsel program or legal services, mediation, anything like that, where you start doesn't have to all rest on one model or one intervention. So with that, I want to take a little deeper dive into sort of some of the different models around eviction prevention. So there are some legislative interventions like right to counsel ordinances. They have been passed in cities like New York City, DC, San Francisco, and Philadelphia. And they've had some pretty compelling success with New York saw a 25% reduction in evictions, as well as an analysis of a right to counsel program in Philly saw that, a $3.5 million investment in legal assistance for low-income tenants resulted in over $45 million in cost savings to the city annually. We are also seeing other court-based intervention models like in Kalamazoo, Michigan, as well as the EPIC program here in Montgomery County, Pennsylvania, which really looks at blending legal counsel and mediation the day of an eviction hearing, along with supportive services and financial assistance. In Kalamazoo, they saw their homelessness rate go down by 9%. In Montgomery County, they saw 85% of program participants avoid evictions. And we are seeing pre-filing mediation programs being used in communities like Cambridge, Palo Alto, in Pittsburgh, and in Philadelphia. And what we're seeing is that about 80% of the time, these mediations are resulting in a successful agreement that is adhered to by both the tenant and the landlord. So we're seeing some really, really compelling outcomes that are really making a dent in the eviction crisis. And we are happy to take a deeper dive into what's happening in Philadelphia, in Pittsburgh, and in Lansing, Michigan. So with that, I am going to pass it over to our first panelist, Elizabeth.
Thanks, Gail, and thanks to everybody for having me today. It's really an honor and privilege to be talking to legal aid programs and for you all in Pennsylvania to have invited me. I'm just going to share my screen with just a few slides. So I'm going to talk about our eviction diversion program models. And like Gale said, they look different from county to county, from state to state, and that's okay. That's how it should be. Because you are going to be determining programs based on your resources, based on your community partners, based on the accessibility of the courts, based on so many different factors. So for our programs in Ingham County, I have kind of a model here. The main partners are district courts, legal assistance, whether that is legal aid, partnering with law schools, which can be a great partner, as well as community agencies that involve, that can be rental assistance agencies, that can be relocation assistance agencies, that can be mediation agencies, that can be code compliance agencies. But those agencies definitely are critical to sort of the wraparound element of eviction diversion programs, which really at the heart are community-based programs that address not just the eviction, but really a holistic approach to preventing homelessness and improving the stock of quality and affordable housing in the city in which they're run. So just some general concepts, like I said, this community program. In our programs, the tenant can enter the system at any point. So the tenant can enter the system by contacting a community agency, who then refers them to legal assistance, who then can represent the tenant through the court process. And once they receive the conditional dismissal, can then get help from the agency to get that paid off. Like that's the idea. And it's cyclical, it's circular, it's a group effort. The tenant can enter the system by contacting legal services when they receive the court documents summoning them to court. The tenant can enter the system when they actually go to court that day and we meet with the tenant on site for the first time. Obviously, that's not the most ideal first contact for a tenant for representation in eviction action, but nonetheless, if that's the point we're meeting the tenant, then that's the point they're entering our system. General concept of right to counsel effect. Like Gale said, there are many cities that are passing right to counsel legislation. I think that's fantastic. That hasn't happened in our area. The closest thing is in Detroit. They're trying to get that set up, and I think that they will be successful at it. But in the Lansing area, that's not something that our legislature has, or city council or anybody has really taken a stronghold behind. And so right now we're creating programs that can look as close as possible to a right to counsel effect, which means that we're on site and available to speak and represent any tenant that comes through the courthouse doors, whether that's the first time we're meeting them, or like I said, if they've entered the system at any previous point, if they've contacted us, if they've contacted another community agency, and it can be at various points that they are in the process of eviction paperwork. So in Michigan, there's a 7-day notice for non-payment that the landlord has to give as a jurisdictional requirement before they can file a case in court. And then if the tenant doesn't pay what they owe in those 7 days, that is the gateway that allows them to then file in court. So a tenant may contact us at the point of receiving that notice. A tenant may contact us at the point of receiving the actual summons to go to court. Rarely, but occasionally, a tenant will contact us saying, you know, I've had this hardship. I'm not going to be able to pay my rent this month. I need some help. Usually, you know, our clients are coming to us in crisis, and it's not really a long time frame before they're headed to court. A big, I think, a positive point of having eviction diversion programs that see every tenant is that you can identify defenses. You can educate the tenant population and educate the landlord population. And when I say that, I mean you can identify patterns. So if we see, you know, so many tenants that are coming to us that have this specific issue, that might be a broader health issue. That might be a broader issue for one particular developer. That might be a broader issue for, you know, a specific landlord who hasn't registered or certified their properties. In Michigan, in some municipalities, that's a requirement that properties has to be registered and then inspected and certified in order to be a rental. Not everybody follows that, and so that can also be a defense and a point of improvement for a community based on a program that sees every case coming through the system. Otherwise, we wouldn't see that. We might catch 1 or 2 tenants that are calling through our intake line, but unless we're there talking to every tenant that wants to talk to us, we'll miss things. There'll be gaps. And sometimes that's fine. We can still, you can still chart and catch patterns the other way. Another great thing about these programs is they end up in a conditional dismissal that ultimately, by its name, is dismissed, rather than a consent judgment, which would stay on their landlord-tenant record as well as on their credit if there's a money judgment. And so by avoiding a judgment and entering a conditional dismissal, which if the tenant complies, that will be dismissed, they're able to maintain their credit, obviously puts them in a better position to find future housing, to maintain and stabilize themselves at that moment, and a better future going forward. And as I said, these programs really can help transform a community. When landlords know, when developers know that there's going to be someone looking at that case, when there's going to be legal assistance, when defenses are going to be assessed, it's my hope and my belief in our results so far that that can definitely make an improvement in what cases are coming to court. A landlord might think twice about bringing a case to court when they know that that case is going to be looked up and down by an attorney from legal aid, ready to represent and defend that tenant if the landlord has not done what they are supposed to do as far as registering, certifying, keeping the property habitable, fit, and safe for the tenant, which are the requirements under Michigan state law. And so the way it looks the day of court, like I said, the tenant can enter at many different points, but the day of court, we're meeting with tenants, we're negotiating with the landlords, we're trying to ascertain if there's defenses, if there's repair issues, if the landlord can fix those issues, if it's a bigger issue that needs to be litigated, if the tenant wants to exercise their right to a jury trial, which we still have in Michigan. Those are all things that are happening on the spot. And we're able to resolve the vast majority of the cases when we're doing in-person programs. Obviously, things are a little bit different now, and I'm going to talk about that in a second. But when we're doing in-person programs, we are really able to resolve many of the cases, most of the issues right there on the spot, and are able to enter a conditional dismissal with the court that day. And so that's our main role. The court, what they have done in planning for these programs is to schedule their dockets in a way that allows for legal services to staff the program. And when I say that, I mean that court might have been hearing landlord-tenant cases every day of the week, depending on the judge. And when starting a program, we have negotiated that they schedule their landlord-tenant cases on 1 or 2 days a week so that we can staff those programs in a way that is effective and repeated every week. So for example, in Lansing, we're there on Wednesdays all day, every day, every week. And in the 55th district, we're there on Thursdays every day or every week. So let's go to a little bit of data. And let's see if I can zoom in here a little bit. So this is the data from our program that we started in Mason, which was our first program that we started in the end of 2012. We started September 2012, and we did that by going to visit the only other program that was in Michigan at the time, which was in Kalamazoo, Michigan. We went and visited their program, watched what they did, brought it back to our community and said, okay, how are we gonna make this work for us? And then it has developed and evolved into the program that we have today. And these are the results that we've had since 2013, which I'm really proud of pretty much across the board as far as, new filings down, default judgments are down because now they're conditional dismissals. The default rate is down. The default after dismissal agreement is very low, and evictions generally are down. So really across the board, every measurable statistic is a positive outcome for this program. And then this is the data that this is a slide I'm really proud of. This is zoom in here. This is the default after agreement, because really a critical part of the program is having a conditional dismissal instead of a judgment so that it doesn't affect your landlord-tenant record or it doesn't affect your credit report if there's a money judgment. And so that's really important for the broader wraparound stabilization and maintaining of your housing, stability, and credit on a sort of a larger scale. And so the default after the conditional dismissal is really important, because if we're doing these conditional dismissals that are ultimately ending in judgment and an eviction anyways, then that really undermines the program. You know, we have to rethink what we're doing. But the outcome is, I'm, you know, very proud of. I hope it continues to improve, that 75% of the conditional dismissals that we enter are not defaults. They result in positive outcomes where people are able to maintain their housing. They do not become homeless. They are not evicted. And it's definitely a benefit in showing the results of this specific program. That's in our Mason program. And so that program is a 2-judge program. It's a more rural area. It does have some urban areas, but it's a more rural area. The Lansing court is a court that's double the size of the Mason court. It's a 4-judge bench. We had a pilot program that we started there based on our Mason model. We started that from September to December of 2017. And there's a study that was done by Michigan State University on that 3-month period of the pilot program. And I have a link there if anybody is interested in reading it. But really, it just shows both the default rate and the eviction rate significantly decreased during the time period that we were running the program. We just started the program again in August with the entire bench. Our pilot program was with 1 judge, and now our program is with the entire bench. And so I hope to have some follow-up statistics, hopefully maybe end of next year or early 2022 on sort of a year's result of statistics from the full program. And then I'll wrap up with how our programs have changed due to COVID. Obviously, in March, all of our programs were in person. We had programs, like I said, in Ingham County, and then we had a program in Livingston County, which is a very rural county. So our programs really spanned very rural, semi-rural to very urban, and the volume of cases, size of the courts varied from court to court. And so the programs, as you would expect, very much were different depending on those facts. And then in March, when COVID hit, we had to make some changes. And so I just have a few things highlighted and of how we have adjusted to still be implementing our programs and even expanding them. So in Michigan, there was legislation on the state level that allowed for expanded programs, asking for eviction diversion programs to be set up in each of the district courts in Michigan. So that was, as you can imagine, a huge undertaking. Legal Aid was the, main grantee for that. And so our programs, we have 5 counties, 7 district courts in our Lansing office service area. We had programs in 3 of those courts, and then we're charged with setting up programs in all 7. And so that has been a huge, like I said, a huge undertaking, but I think a very successful one. I will say our staff is overwhelmed. I'm also overwhelmed, but I think that we are working through it, and I'm really excited that it's sort of becoming a norm in the Michigan courts rather than the exception. And so we instituted a specific intake line for EDP cases that is, separate from our usual legal issue intake line for our office. And that's been pretty successful. Obviously, that takes significant staffing to be answering those calls and giving that advice. And that comes pre-court and court intakes. We still have some programs that are doing in-person, even though the Supreme Court in Michigan has said that any cases that can be done virtually should be done virtually. There are some courts that are resistant to that. And so some of the programs are still in person. Those are usually in very rural counties where technology is at a minimum, and there are usually very small amounts of cases in those service areas. And so we've been able to still go there with minimal staff and be available to do intakes and represent tenants in those areas, obviously within CDC, state, and local safety guidelines. And so our staff, goes there with masks and protective gear and is making sure that the court is following the guidelines that have come through the Supreme Court under administrative order. for district courts. But the majority of our programs now happen via virtual hearings. So our courts are using Zoom, and this took significant planning in the months where there was the moratorium on landlord-tenant cases, where I was planning with the courts in our service area, trying to set up what the programs will look like with a virtual platform. And what most of our agreements, and they're different, again, a little bit different depending on the court, but what most of our courts are doing is we are still on site as if we were in person, but we're just on site virtually. And so we appear in the courtrooms, in the Zoom courtrooms of our district courts. And when the tenant appears via Zoom, they're asked if they want to speak to a lawyer, as well as ask some other questions, again, that are dictated by the Supreme Court through their administrative order on the reopening of district courts. And we go to a breakout room in the Zoom courtroom with the tenant where we're able to do the intake and assess the legal issues, assess any repair issues, defenses, and financial assistance that's needed. We then do referrals to the community agencies in courts where they're not also on site. We have a few programs where our community agencies, like Department of Health and Human Services and our local HARAs, where in Michigan, that's kind of like our coordinated entry agency for housing, are also on site in court, and the court is willing to navigate tenant from agency to agency. Most of our courts are not doing that. Most of our courts are allowing legal services on site to meet with tenants in breakout rooms, but not necessarily the community agencies. We do have 2 courts that are willing to do that, and it is very helpful so that we don't lose people in the process. Because many times, as you know, tenants will say, okay, I'm gonna go talk to this agency, and then we lose people through the cracks in that translation. But it's definitely been quite a learning experience, and I think our staff is now getting used to appearing virtually, making argument virtually, meeting with tenants virtually, and doing follow-up virtually as well. And so we're still able to have that on-site, willing to talk to every tenant. It's now just virtual via Zoom. Now, obviously, doing things virtually in that way present access issues and technology issues. And so we have also negotiated with courts, as well as, making sure the administrative order from the Supreme Court is followed regarding access issues, where courts, if a tenant does not have the ability to appear via Zoom or via audio phone, which is also a second alternative, that they are able to contact the court, and the court will give them an in-person summons, an in-person notice, which is not ideal because, usually there's some overlap with people that are most vulnerable that do not have the technology and do not have the ability to appear via Zoom. And those are not the people that really should be, putting themselves out there, but they have the right to appear. They have the right to make their case. We're trying to sort of catch those people beforehand, do intakes with them separately, and then appear for them in the courthouse. Also during COVID, there's obviously additional federal, state, and local tenant protections. There's, various moratoriums. We just got the CDC protections that are, available for eligible tenants in certain cases. There's also a significant amount of additional federal, state, and local resources for tenants to prevent eviction. There's additional ESG funding, there's additional CDBG funding, there's additional CARES Act funding. So, and some local government funding as well, depending on where you are. And so those are also ways that we are adapting and, being flexible with our programs depending on the circumstances. And then my final point is that really all of these things, all of the way that we've adapted during COVID is the result of community education and collaborative efforts towards prevention. So with the additional federal, state, and local tenant protections, that's something that legal aid has really obviously taken the lead on, making sure that our communities are educated, making sure that our community partners are educated so they can then make sure that the information is disseminated to our communities. And we're also being very intentional about the additional resources that are coming to our communities. Many of those resources have time limits on when that funding can be spent. And so we're very much doing a calculated, intentional prioritization of those funds to make sure that these funds that have to be spent by December are spent. And then once those funds are spent, these funds are available. Or if the person is not eligible for funds in pot A, they're eligible for funds in pot B. And so that took a significant amount of community collaboration and time in order to set up a system where we're most effectively and efficiently using our resources and funding to prevent as many evictions as possible. And so that's an overview of our programs in Michigan. Thank you very much for your time, and I will hand it, I'm happy to answer any questions now or at the end, and now I hand it over to our next presenter.
I think we have a couple of clarifying questions that
Okay.
just knock out right away. The first one is this an LSC funded program?
Yes, we are LSC funded program, which brings with it several additional requirements like retainers and attestations, like income levels. And so some of the tenants are eligible under the income levels. However, the state of Michigan has, given this grant until December, which has made tenants that are even over income are eligible under the Michigan State Bar Foundation grant. But those that are LSC cases, those I will say those are a challenge because LSC has told us that they're not accepting digital or electronic signatures. And so it has been quite the feat to figure out systems to send out and get returned retainers and attestations, which as other LSC funded programs know, are requirements for cases.
Great. And are people able to initiate services with you prior to filing, whether it's a community referral, a tenant, or a landlord?
Yeah, absolutely. So in that initial sort of 3-person pie that I showed in the beginning, the tenant can enter at any one of those. The tenant can enter by contacting a community agency that will then refer it to legal services. The tenant can enter it by contacting legal services either before court or when they receive the summons to go to court, or the tenant can enter the system, the program, when they're actually at court and we're seeing them for the first time that day. Obviously, the earlier the tenant enters our system, the better, but the tenant can effectively receive services at any of those entry points.
Great, thank you. And with that, we're going to pass it over to, I think Megan Stanley is next on our list of speakers.
Hi, everybody. I'm Megan Stanley, the Executive Director for the Pittsburgh Commission on Human Relations. Thank you for having me, and thanks so much, Elizabeth. That was all such good information. I'm excited to learn more about that program. Before I share my screen, I'm going to say, here I am, another non-attorney talking about eviction diversion and mediation, and so what am I doing here? The Commission on Human Relations is the City of Pittsburgh civil rights agency, so we investigate complaints of discrimination, including in housing, and we know from all the great data that's been collected by local organizations that evictions disparately impact renters of color, communities of color, and specifically a lot of single mothers. And so knowing that these protected classes are being harmed by evictions, we wanted to think about eviction diversion and creative ways, even before COVID hit, that we could impact this issue. So I'm gonna go ahead and try to share my screen. Okay, and hopefully everybody is seeing that. So I don't think that I necessarily need to talk to this group about why we need eviction diversion, but I do like to go through some of the numbers just to make the point that it was really important for us to create or to know what the data points were. So knowing what the problem is so that you know if you're making any movement, and especially if you have limited funding, how to target interventions in different ways. So are you trying to move the needle on the number of evictions, or are you trying to target populations like the lowest income renters? So in Pittsburgh, in the city, we had about 5,000 evictions a year. We had about 13,000 in Allegheny County per year. And this is, again, pre-COVID and looking back about 10 years. And obviously landlords winning judgments, most of the time, about 85% of the time. Tenants only won judgments 1.5% of the time, so a really, really small margin. And as somebody brought up in the chat earlier, we know that an eviction filing itself, even in that rare instance where the tenant is successful, the filing itself is harmful, right? It's sort of a blacklist down the road, another landlord sees that and says, oh, there was a landlord-tenant action, there's something going on here, I might not rent to them. So we know it impacts future housing opportunities. Something else the data told us was that the vast majority, so about 95% of evictions that we had filed were against tenants paying less than $1,000 a month in rent, and about 35% of them were tenants who were paying less than $500 a month in rent. So these are really low income tenants. A lot of them live in housing authority properties. They're paying a small amount in rent, and so the judgments weren't even for that much money, but there were a lot of policies that were making it such that these renters were targeted first for eviction. And we know that evictions obviously are really costly to landlords, as Gale brought up. They're detrimental to tenants for years into the future, and they really just impact the entire community. So cities in Michigan, including Kalamazoo, Pittsburgh, Philadelphia, I'm trying to think, Norfolk, and Richmond were the 5 cities that were involved in the National League of Cities eviction prevention cohort. And I was one of the people representing the city of Pittsburgh who went to the initial convening right before COVID hit, and we were thinking about eviction diversion and how we could create programs locally that would really matter for the community and make an impact. And so we came up with a plan that obviously pretty wildly changed, and a lot of it was really escalated in COVID. But one of the things that we realized that was missing here locally in Pittsburgh and in Allegheny County was a mediation program for landlords and tenants. So here, you know, we have fantastic legal aid resources, but unfortunately, you know, people are entering that system when they're going to court a lot of the time. So there, again, if the filing is problematic, there weren't many things in place that tenants and landlords could access to try to mitigate a housing problem early on. So our big focus in that cohort has been to build out this mediation program, which has just started. They've just started doing mediations and taking referrals and have all of the staff on board, and I'll get to that. But we were really excited to bring this into this mix of the components of eviction diversion. So mediation being a single service provider, we started out not having necessarily an organization that was already providing a service like this, but we have a really strong local mediation council, so professional association that local mediators who were already trained mediators were a part of. And so the idea was to go to them and say, would you like to also do some housing mediation to prevent evictions? So adding on some specific landlord, tenant, and eviction-based training so that they understood that landscape, and not just, this is a business transaction, you know, a landlord is owed money, or there's a problem and there's a contract and this is what to do with it, but really humanizing it, bringing people into the trainings. And I know some of you here have been to that training, but bringing people into that who have lived experience, you know, they've been through an eviction, they advocate on behalf of tenants who have been evicted, and so they really understand it in a different way. And I think starting the training that way has been really impactful. So the mediation program was initially going to be pro bono, trained mediators. Thankfully, we got enough funding that we're actually able to provide a stipend per mediation for all of the mediators who do this, and we have a really big pool of mediators. On top of mediation, obviously, there's rental assistance programs, assessing at mediation intake if somebody has access to those, if non-payment is part of the eviction issue, making sure that they do apply, a little bit of walking them through if they're eligible, or getting them hooked up with resource navigators locally who can help people apply for those programs. Obviously, we have the current CARES money that's helping with rental assistance, but then there's existing Housing Opportunity Fund money, or ESG through Allegheny County. Also asking them about legal assistance. So have you already talked to anyone at Legal Aid? Would you like to? Can we help you set up a consultation? We're still working through some of these connection points, but making sure that people are aware of their right to get legal counsel, to make sure that there's a warm handoff, that they get connected, so they're not finding all of this information on their own when they're going through these issues. Another really big component for us has been the landlord and tenant outreach, and I'll talk about this in a minute, but Making sure that landlords buy in early to the program we have found is really important, and making sure that tenants know about it. So to somebody's earlier question about like, how do you get people before they're already being sued? I think making sure both parties know about their options and understand the incentives for this. And there is a strong incentive on both sides. Obviously, for a tenant, you might be able to resolve this without getting an eviction filing against you. For a landlord, there's a study from last year out of Richmond that on average, an eviction costs about $5,000 per unit. So there's the rent that you were owed that you're unlikely to recover. There's the court cost filing fees that you probably also won't recover. The money to turn over a unit, and then the time spent waiting for a new tenant. And in COVID, you can imagine, based on where the unit is located, that might be even longer than usual. And also knowing that court cases may not be processed right now. So strong incentives on both sides, and making sure that they understand that and know what this mediation is, because I think a lot of landlords have heard of or have maybe even interacted with some sort of mediation in a different sense. And it was, it's not what this program is meant to be, which is really a diversion and an early intervention. And then finally, just social service and financial coaching support. So making sure that, you know, if somebody's experiencing a housing crisis, they probably have a lot of other things going on. Maybe they're putting off paying medical costs that they need to pay, or there's a food access issue, or something going on with their kids. So just assessing those things as well and making sure that they're connected to those programs. So then how is the program utilized? This is, you know, I have talked to mediation programs across the country to sort of figure out what does it look like? How have you done this? What were your lessons learned? So we can learn from those early. And that's really how this was built out. So the mediation can happen sort of like Elizabeth said. There are a lot of different points of entry into this. So a landlord or a tenant could just voluntarily seek mediation. And at the end slide, there's the contact information, but basically they can contact us or through a resource navigator or a community agency, say, I know there's a housing problem, especially right now. I know I'm not being evicted, but I might be when a moratorium is over. I haven't been able to pay rent, or there's a habitability issue and I don't feel like I should have to pay rent because this unit isn't livable, or any number of things that could come up. So either one of them could say, I want mediation. The mediation program will then reach out to the other party and make sure that they're on board. You could have landlords that utilize mediation as a mandatory step before an eviction. And this has been something that we worked really hard on here locally. So Action Housing was the first landlord to be on board in this way and say all of our units in Allegheny County, with the exception of, I think, cases of violence, there will be, we will use mediation as a mandatory step before we file for an eviction. So from there, it spread to some other large landlords and also to a housing authority site. So right now we have about 7,000 units in Allegheny County that are covered under that model, where the landlord is making mediation a mandatory step on their end before filing for an eviction. You could also get referrals through the MDJs for eviction filings, and this would be voluntary right now. So the way that it's working, you know, I think there's this mandatory conference that judges are having in eviction filing cases where they're asking, have you applied for rental assistance? Have you done these things? So mediation can come up there. We know we have some MDJs who, once we're back in person, have like put out the mediation rack cards so people know, hey, mediation is a free option. I could try this maybe before I'm filing in court. So putting that information out there so landlords know about that. Fair housing organizations like the commission can refer cases that are just outside of their purview or their jurisdiction. And then housing authorities can utilize eviction diversion in the first month of issues instead of filing for eviction. So we know that locally, the housing authority here filed a lot of evictions, but only about 10% of those were actually led to possession. And so that meant that a lot of people stayed in their units. They ended up keeping their housing, but they had these detrimental filings on their records. So we wanted to make sure that we got some buy-in so that that potentially wouldn't happen. So then after mediation, obviously referrals to legal assistance. If the mediation you know, if the case doesn't settle and we think that it's going to move forward, making sure that the tenant is getting a referral to legal assistance is really important in helping them make that contact. Making sure that they know about and hopefully have already applied for, and we've connected them to rental assistance programs, as well as housing counselors or case managers as needed. And that's a case-by-case assessment that has to be done. And then if an agreement is reached, it's legally binding agreement, and obviously a breach of the agreement could be dealt with in the courts. And I know that's a question a lot of landlords have had. So then the goals of this eviction diversion program, we initially built this out thinking this was going to be a small pilot that we did, and we were going to iterate and see what happened after that. Then COVID hit, then COVID stayed around, you know, then we were just in a huge housing crisis. So something that was supposed to be 100 cases a year has grown exponentially. And while I'm all for starting small, I do think that in the midst of a crisis, we needed to have a bigger response. And luckily, thanks to our funding partners, we were able to grow that. So the initial phase took about 4 to 6 months. And that's when we're talking to community groups. We have a convening every other week of local housing advocates, housing professionals, tenant groups, the courts, DHS, continuum of care people, sort of everyone in this housing ecosystem to meet. And I know some of the people are on this call today, but I think in that, just hearing like, what did people need? Who's providing services? Where do they fall in this map? How would they align with this? So making sure that those partnerships were formed and then getting funding approved. So the funding for this, initially we got some CDBG CARES money through the city of Pittsburgh, also Allegheny County ESG, foundation funds, and then plan funding. And so in year one, which we really just started at the beginning of September, we started with an initial pool of 25 mediators. We then hired a program administrator and a mediation and engagement director, and contracted with some local organizations for both landlord outreach and tenant outreach to make sure that that was a continuous process. They were getting buy-in, they were getting their questions answered. We really want to take until the end of the year when this moratorium expires to make sure that people know about and are utilizing the program while it's one of the only options that they have to solve housing disputes. Obviously, we had a goal to increase diversity of our mediator pool. Our mediators initially were a lot of older white men and women, but largely women. And we knew that that wasn't reflective of the people that were facing eviction. So making sure that people, again, who were tenant advocates, who worked in the community, who really understood this process and what it meant, especially for a tenant, we wanted to utilize that pool of people to grow our mediation pool. So I think just last night, the first community-based training wrapped up. So that's the 40-hour basic mediation training provided for free to community mediators who applied to be part of the program. So we went from having 25 mediators to an additional 24, so almost 50 mediators now to use, which is a really, really broad pool. And I think there's already a waiting list of another 20-some people to get that training. Direct referral systems were established with our partner agencies for needs, obviously beyond dispute resolution. So that legal assistance, rental assistance, just basic need assistance, and making sure that people are getting connected to all the programs that they need, understanding that housing doesn't just affect your housing, but all the other aspects of your life. Our goal is to do 500 mediations in the first year. I will say, though only a handful of mediations have been conducted, all of which have been successful thus far and ended in a settlement, I think in the first week there were 50 referrals for mediations that are being scheduled right now. So I do think that and that number, you know, would only get us to about 5% of the evictions that we're seeing. And we had a goal of 75% success rate in avoiding eviction and displacement. I think that's a reasonable goal. If you look at, Gale had briefly showed other programs across the country, you know, they have somewhere between 70 to 90% success rates. And that's, you know, been over time and in many different locations and different types of mediations as well.
Megan, I'm sorry, this is Kelly. I just need to launch the CLE poll box for attorneys asking for CLE credit for this session. Please respond to the poll box now. Thank you. And Megan, feel free to continue. I apologize for interrupting.
Oh, you're fine. I'm just going to try to minimize that. Okay, well, hopefully everybody's still listening. Thank you. So really briefly, our eligibility and the intake process for mediation. So because we're getting CDBG and other forms of federal funding, the priority is given to tenants who fall at or below 80% of the area median income. Obviously for the ESG clients, it's 50% or below. And I do think based on the data that we already had, that is going to capture most of the filings. There is room to do mediations outside of that. We just want to give priority to those lower income renters who are the most vulnerable. And while many cases involve non-payment, as you might expect, really any issue that's causing any potential housing instability between the landlord or property manager and the tenant could be referred for mediation. We've also gotten some requests for issues where it's not between the landlord and the tenant, but between two tenants. And I think the line there is, if that issue goes unresolved and will result in eviction, then that's something that could be mediated. So one landlord reached out and said, I don't have an issue with either of these tenants. However, they are fighting with each other and harassing each other to the extent that they could potentially be evicted because I can't let this continue to happen. Could you guys mediate something like this? So I think that's sort of the line there. And then during the intake and pre-mediation, the tenant obviously is asked if they're working with any other organizations. So have you contacted another organization about these issues? Who are you working with? What did they say? Have you applied for rental assistance if you owe any rent? If not, making sure that they get connected to that, because we know that it does take several weeks to go through that process. And luckily we have a great team of resource navigators who are able to help with that. And then once contact is made with both parties and they're willing to mediate, Just Mediation Pittsburgh, the mediation program, tries to schedule the mediation within 2 weeks. And I know that's a question that a lot of landlords have asked, if I'm going to delay potentially having to go to court, how long is it going to take? I don't want to lose another month's rent if I could avoid that. So, in case anybody has any questions or wants to know more about the mediation program, the website is justmediationpgh.org. I also put their phone number in there, and Aaron Erb is their executive director, and I just popped his email in. And I think that's all for my slides. It looks like there's a lot going on in the chat. So
yeah, I'm going to ask a couple of clarifying questions and then we'll move on to Rachel. So I think the first clarifying question is just, where in your process is there a referral for legal consultation? And how do you ensure that tenants are entering into agreements that they can essentially keep and fulfill?
Sure. So tenants are being asked at pre-mediation at intake, so before the mediation is ever scheduled, if they've already contacted legal aid. If so, who are they working with? Because we want to make sure that that person knows what's going on. And if not, would you like to be referred to legal aid? You could get a consultation, making sure that we connect them. They know the options for that. We're still working through that. I know some of the people are on this call, but wanting to make sure that they both have the option to get a legal aid consultation beforehand. And also, if somebody says, this agreement sounds like something I could do, I'm fine with it, but I really want to consult with somebody, trying to ensure that they have options to consult with legal aid before signing something, just to ensure that everything is legal and something that they can hold up their end of that. That's also where, depending on the agreement, I think I briefly mentioned like the financial empowerment centers. So if the agreement is going to be you owe back rent and you're going to pay an additional $100 a month to catch up on that, but your budget is such that you don't have that wiggle room, we want to make sure that people aren't entering into an agreement that they can't uphold.
Great. And then how are you working with folks who maybe have limited English proficiency?
So we are partnering with a local organization, Global Wordsmiths, to provide translation and interpretation services. So right now, much like Elizabeth said, a lot of things are virtual. So making sure that We have translators and interpreters available or can do captioning that would be in somebody's language of preference, and getting flyers and outreach materials translated. I know that the program administrator is also a Spanish speaker, so making sure that we have that available if somebody just calls and needs help, but working on getting everything both translated into the most common languages, but then having language interpretation available for anything that they need.
Great. And with that, we're going to move this agenda along and hand it over to Rachel Garland from Community Legal Services. Thank you.
Hi, everyone. Thanks so much for joining us this morning. This is sort of an exciting world to be in, where we're speaking about eviction diversion and are actually talking about all of these programs that are set up so far. So I'm going to share my screen, but in Philadelphia, we don't quite yet have data to share like some of the other areas do. But starting on September 1st, sorry, showing how I turn it into perfect, thank you. All right, so in Philadelphia, beginning on September 1st, we launched our eviction diversion program. It is based on a pilot program that began last fall and was unfortunately great in terms of setup, but not so great in terms of anyone actually signing up. So the pre-filing pilot program that began last fall was a voluntary program. So landlords had to agree to go through it. And so there was really only about a dozen cases that went through it. Most of them actually after the pandemic hit and landlords realized that there was going to be moratoriums for a while. But really with a sampling of 12, there wasn't much data that we can call from that. And so what began in September of this year was a program that is actually mandatory right now. And so we are expecting to have far higher numbers. And it is mandatory as part of City Council legislation that was passed on July 1st, well, signed into law on July 1st, requiring, due to COVID, requiring that tenants who certify to a COVID-related financial hardship, their landlords have to go through a diversion program before filing a new case in court. So the eviction crisis, I think, has already been fairly well covered by the other presenters, but here's just some basic information. In Philadelphia in 2019, we had 19,000 filings against tenants in court, which is a volume that's down from the 24,000 filings that we had in 2016. However, now with unemployment rates skyrocketing, we're concerned that the number of tenants who could risk facing eviction are even higher. There was a moratorium on evictions, both on the state level, but also on the local level. They ended August 31st, and our eviction cases have resumed in court as of September 3rd. And our eviction lockouts were supposed to resume on September 8th, but there was a 2-week delay due to the CDC order, and those will be resuming this Thursday. So the pre-filing program, again, has been talked about by our other presenters, is really intended to keep tenants out of court, to prevent tenants from having a court record that could harm them in the future when they're trying to find new housing. And also because here in Philadelphia, there was a recent study done by the Temple Scheller Center and Professor Lynn Reeser that talks about the fact that 53% of lockouts follow from a default judgment. Even though only about 30% of judgments are defaults, over half of them are what lead to a lockout. And here in Philadelphia, we have serious concerns about how service is being handled, the service of writ of possession, whether it's actually being done. And there was another session, I think, that talked about this more specifically, and there's been a number of articles over the course of the summer. So the thought of, in the midst of a pandemic, someone being evicted due to a judgment that they may not have known about back from February or March was deeply disturbing to many people, and that's what gave some of the impetus to the current diversion program. The pre-filing program, the goal is to reach a sustainable agreement that would avoid a court filing. This is beneficial for both tenants and landlords, but it is a requirement that there be time and that there be resources in place, like a housing counselor or an attorney to represent the tenant, in order for it to be successful. So the current eviction diversion program comes about thanks to the Emergency Housing Protections Act, which was a series of 6 bills that were introduced by 3 city council members in May. They were unanimously passed in June after, unfortunately, some amendments due to negotiations with the landlord lobby. It put in place a blanket eviction moratorium through August 31st of 2020. So this was for all tenants unless a landlord could show imminent harm or a threat of imminent harm to the landlord or the property. And then there were 3 protections that were specific to tenants who could certify to COVID-related financial hardship. One is that they could ask to have their late fees waived from March of 2020 through May of 2021. One is that they could enter into a 9-month mandatory repayment agreement beginning September of 2020. And the third was that the landlord must go through an eviction diversion program prior to filing an eviction case in court. And this is where we hope that we will actually see this eviction diversion program really take off, is because it is mandatory for the landlords. So the eviction diversion program overview is similar to what we've heard about in the other areas. The landlord starts under the Emergency Housing Protections Act by having to send a notice of tenant rights to the tenant. And then the tenant has to return a COVID-19 financial hardship form, which says that either they have lost income, they lost their job, they couldn't find a job, they had to take time off to care for a family member, or they had to take time off because they themselves were sick. It's a fairly broad certification form, but the landlord really doesn't have to go through the diversion program if it hasn't been provided. The landlord then goes into an online portal and requests a conciliation conference. We're working with our sister organization, PLA, Philadelphia Legal Assistance. They screen all of the entries from the landlords in the portal to make sure that they filled out the information that they need to fill out. And then they reach out to the tenant and they schedule the tenant with an appointment with a housing counselor. All of this is happening virtually right now, but the housing counseling agency will then follow up with the tenant, and PLA then connects, once the tenant has been connected with the housing counselor, connects the landlord with Good Shepherd, who is a local mediation agency that had been doing the pilot program. They use volunteer mediators, and they have done a number of trainings recently to expand the pool of volunteer mediators, and so they handle the logistics of the mediations. For right now, the mediations are happening by phone, though at some point we'd like to lay in the option to do it by Zoom, and at some point, hopefully, be back to doing it in person. So the housing counseling role, and the housing counseling agencies here in Philadelphia have been doing mortgage foreclosure diversion mediation and support for years now, ever since the mortgage foreclosure diversion program was set up in 2008 in response to that crisis. So the housing counselor role is to meet with a tenant pre-mediation, assess their finances and tenant goals, find out what's possible and spot check for legal issues, and refer to the legal services agencies here in Philadelphia as needed, really to help the tenant apply for rental assistance. In Philadelphia, just last week, we learned that the CARES Act funding through PHFA is going to be matched by the city, because there were 10,000 applications by tenants for rental assistance. Only 4,000 landlords chose to participate because the rent here just is far more than $750, and so many landlords were refusing to take the $750. So now, just as in Allegheny County, the city is matching up to $1,500 a month, and so we're hoping that many more tenants will be successful in getting their landlords to cooperate with rental assistance. And then the housing counselor can go as far as proposing an agreement to the landlord. If they're able to work it out at that point, there's no need for a mediation session. If not, it'll be scheduled for a mediation session, and the housing counselor actually attends the mediation with the tenant to support them and help level the playing field during the mediation session. And then we have built in sort of a check-in to make sure that these agreements are actually working, that there'll be a 45-day post-mediation check-in that the housing counselor will reach out to the tenant and just see how things are going, and can always bring it back to mediation at that point. So we talked a little bit about the role of our sister agency, Philadelphia Legal Assistance, in handling these calls and scheduling them. Community Legal Services, where I work, we're sort of doing the back-end support. So we've been supporting the housing counselors with questions or issues, reviewing referrals for possible legal representation, Supporting the housing counselors, the mediators, and tenants during the mediation. We're available by email, phone, and on a Slack channel in real time to be able to handle questions as they come up. And then we've also been providing a lot of the support and training to all the different aspects of the program. The mediator role, so far they're all volunteers. Their goal is to facilitate a sustainable agreement between landlord and tenant, set the stakes of eviction during a pandemic to make sure that everyone's sort of on the same page as to that we're trying to stabilize housing, reduce in writing any agreement, and actively facilitate dialogue by setting terms of who speaks, topics, areas of mutual interest, and possible solutions, including outside resources like rental assistance, and to schedule follow-up sessions if needed, because we all know that negotiations sometimes need a little bit of a pause or for everyone to do some legwork and then come back together. So the program started September 1st. We have about 50 to 60 applications so far. Many of the tenants have already been paired with housing counselors, and we've been providing a lot of hands-on support to the housing counselors to get them up and going with their first tenants that they're working with, and the first mediation sessions are scheduled for this week. So we are hopeful that the program goes well. We are excited that the reinvestment fund is going to be working with us on data collection, because they did that for the mortgage foreclosure program, and we think that one of the best ways to make this a sustainable long-term program is to be able to show data, just like in Michigan, as to how successful this is in helping tenants and landlords reach sustainable agreements. So I see there's a couple questions. Do landlords complain that housing counselors attend mediation? Well, there haven't been any mediations yet, so no complaints yet from the landlords, but we'll see. Our hope is that, down the road, we could actually make housing counseling available to small landlords as well as a means of support for them. So right now, due to the power imbalance in court, where landlords are represented 80% of the time and tenants are only represented 20% of the time, we wanted to make sure that we weren't recreating that same power imbalance in the diversion program as exists in court. So that's why we prioritized starting with housing counselors for the tenants, but it is definitely a goal of the program to be able to provide some level of support. And there are, on the task force that's putting this together with the city, there are representatives from the Pennsylvania Apartment Association, and so they are available to consult with with landlords also as needed. And does legal aid help tenants of low income? Yes. So any tenant who gets triaged and needs an attorney will be referred to legal aid for us to see if we can represent. There's a couple different legal aid agencies here in Philadelphia that could provide possible representation.
Great. And again, this is sort of a question for all three panelists. Like, what are the strategies that you use to get agreement when you are in these mediations?
I mean, I can, so.
Rachel can go.
Yeah, I mean, I think many of the strategies that we as attorneys have always used in court before, if the landlord wants to see any money, the best way to see the money is to work out a payment agreement. The best way to make sure that their tenant pays ongoing rent is to work out a long payment agreement that the tenant is paying on for many months, plus catching up on the back amount. If what the landlord really wants is their property back, then they might want to waive rent as an incentive for the tenant to move out more quickly. I do think that the dynamics have changed a little bit during the pandemic, because it's not as, landlords I think are less interested in having their tenants move out right now, partly because they know that moratoriums keep popping up and it might be longer time period before they're actually able to lock their tenants out. And so they might be a little bit more interested in trying to get some money now, or they might just be more frustrated. And so, I do think the dynamics of the conversation are changing at the moment.
Yeah, I would agree. I mean, I think right now, since, cases aren't being heard, and knowing that it could be so many months, even once courts are completely reopened, there's going to be such a backlog. We saw 3 times the normal amount of cases filed on that first day after the state moratorium ended. It's going to be so long before a landlord is able to actually evict somebody in so many cases that right now I think a lot of the conversation is around, okay, it's in everybody's best interest to keep this person stably housed and to get you some income coming in through rent. So can we help you apply for those programs? And once that runs out, what will it look like for this person to stay here? Or would it be best for you to, for example, allow them to break their lease and move out without penalty so you can get another tenant in if that's what you require? So I think conversations are slightly different right now than they would have been a year ago, and probably will be different for the coming year.
Great. And then the next question is, again, mediation is something that can be provided by somebody who is not a lawyer and may not have that great depth of expertise on landlord-tenant law, which can be very nuanced. So what are strategies that you're using to protect tenants' legal rights when they are entering into an agreement and a mediation that's maybe not being overseen by an attorney specifically, and still ensuring that those agreements are legally appropriate?
I think here in Pittsburgh, I mean, obviously offering the ability for somebody to consult with an attorney if they want, but a lot of there are different templates that have been created for these agreements for different situations. And that's been in consultation with, the housing court, using some of the templates and agreements that they've used before. So making sure that those are legally sound, and a lot of the attorneys involved with the mediation council have also overseen those. So I think that they have had that once over for the template, but they could be changed in the mediation. So again, offering, if you need to take a few days and get a consultation to have somebody look over this to make sure that it's legally sound, offering that option within the mediation is important.
Great. And then what happens when you just are trying to engage the other side and there's that resistance to mediation overall? I mean, I know we've really talked about sort of the different motivators, especially during the pandemic, but I think it's still important to revisit again, sort of breaking down that barrier to the process.
I think just asking them what they want, right? Like, I think, letting them, well, so I'm coming at it from a tenant's perspective, but I think this works in both directions, right? I think both sides are frustrated right now. I think both sides are experiencing a lot of economic stress. There's a lot of uncertainty as to what's going forward. And so giving them some time and room to vent about all of those emotions. And then once they've gotten that off their chest, having an honest conversation about, like, okay, what is your goal? What is it you want? And then let's talk about what your options are. What would be your options if you went forward with a trial or with a hearing? Like, what's your best case scenario there? What's the timeline associated with that? And then I think once people sort of realize that their best case scenario doesn't get them what they want, then they're a lot more willing to come to the table and talk about some other options. But I think people still think, I think tenants think they're somehow going to be able to get something. And I think landlords still think they're going to be able to get something. And so just letting them know that under no scenario are they going to be able to get what it is that they want. And so they actually are going to need to think more practically about what is available. Sometimes loosens things up, but you got to get the venting done first, because we're in a really tough situation now. And unless people feel like they've had an opportunity to express that, they're not going to be able to move on.
You're basically doing a mediation to get people to mediation. Those good mediation skills. But yeah, I think another thing that works is having, again, we're lucky that we have Action Housing as a nonprofit landlord, but really well respected in the community in the larger landlord realm here. So having them on board, but having some other landlords sort of be the mouthpiece to say, hey, we're using this. This is why we think it's helpful. So it's not just us making that rational cost-based argument, but also hearing it from maybe somebody that they perceive as being on their side and saying, oh yeah, I did have really good outcomes with this, and having some personal stories to share about what they got from mediation, I think is a useful tool to have in the toolbox.
And what are some of the strategies that you're using in Michigan?
So our programs don't have a mediation component. Our programs are just legal representation, and so I haven't been chiming in, but I feel like the arguments are similar as what, you know, Rachel had stated already. You know, if it's non-payment, maybe if a landlord wants his property back, maybe they're willing to waive rent, see if there are repair issues, see if there are, you know, outrageous late fees. Michigan law allows only late fees that are liquidated damages correlated to actual expenses. And many landlords are charging, you know, $50, $75, $100 late fees, which are penalties under Michigan law. So those are things we look for. We're looking for if they're charging pet fees that are really emotional support animals. We're looking at, are there registered registration and certification issues? We're looking at all those things. And then we're trying to, if a landlord does want the money, maybe if they're willing to work on a payment plan with the tenant can put, you know, a significant portion of the payment, maybe get some assistance. And I also agree that I think landlords right now are more willing to participate in rental assistance programs than they previously have been. And we're experiencing several complexes that had even said, no, we're not participating in this, you know, specific Michigan rental assistance program because it required them to forgive, you know, up to 10% of the amount, are now willing to with the added CDC protections. So I think that definitely this is a unique time period, and hopefully landlords will have good experiences with the financial assistance programs and will continue to want to participate even after this period is over. But the more important part is, I think, making sure the tenants are aware of their rights and that we're enforcing those rights and making sure that any defenses that they have are being litigated and that repairs that they have are being made so that habitability issues are minimized, and in the long run, we have improvements in affordable quality housing.
Great. And then again, this is an open question to all three of the panelists, sort of as we are now 6 months into the pandemic. You know, each of you are in sort of different phases in rolling out your program, but what are some of the biggest lessons learned that you kind of wish you had known at the beginning that you would like to just share as advice to people on the call who may be looking to start up a model similar to what you are doing in your communities?
Well, for Lansing and for Michigan, I think staffing is really important. I think it's important to have conversations with the courts about what their scheduling is going to look like, how many tenants are going to be on the docket, and then kind of trying to estimate what the appearance rate will be of tenants so that you have the proper staff to, you know, address the need. I think that that's a huge thing. And our initial staff was not enough. I had to add more staff, which is great. I mean, I wish we had, like, you know, 60 lawyers per program. That would be fantastic, but you know, obviously that can't happen. So I also think it's important to, you know, be intentional about the staff that are, you know, ready for these programs, which are very quick, which are very on the spot negotiation, which are very kind of high volume and a little bit chaotic the way that they play out. And that's okay. It's just that that's in a certain skill set. And so I think that's important when determining staffing for the programs as well. I also think that collaboration with community partners is critical in determining the best approach for community wraparound services for the tenants. So I would say do extra planning, take extra time to get the partners that you need, and consider staffing and make sure that the core investment is there, because I think that's also very critical. If the core is invested in the program and wants it to succeed, they'll be much more supportive of claims that, you know, we're making. They'll be supportive in making sure tenants do talk to legal services, because when you present the program, especially via Zoom, you can present it as, do you want to talk to a lawyer? And if they say no, just move it on. Or you can present it as, this is a program made for tenants. It's a free program. It will help you resolve, you know, with your landlord. And there might be resources that you don't know about. You know, and a presentation like that might make someone more likely to say, yes, I want to talk to a lawyer. So I think that that part is also important to note that you might not think about before.
Great. Megan, I'm going to pose that same question to you.
So it's the lessons learned.
Mm-hmm.
Lots of lessons learned. I mean, I think I talked about one of my main ones, and this was actually a lesson that we learned early from Philadelphia, was making sure, you know, we had early landlord engagement and making sure some people were on board so that we didn't want a system where tenants wanted mediation, but then no landlords agreed to it. So then, you know, weren't able to actually do any. I think also the idea that I mentioned before of making sure that people who have actually gone through an eviction and understand what that looks like from both sides are part of trainings and just the conversations to develop a program. You know, what is really needed. I think data is important, and knowing sort of what you're tracking, what outcomes you hope to get, so that you can see that change over time and know, like, is this program doing what we hoped it would do? But the idea of what we hoped it would do should come from the communities that are affected by evictions. So making sure that you hear from them early and often and are checking back in with them to say, like, is this working for you? What do you need? How can we be more responsive? And just having that good line of communication, I think, is really important and something that you can't miss doing early on.
Thank you. Rachel?
Gail, I'm sorry. If I could just interrupt quick. This is Kelly. This is the second of the 2 CLE polls. Please respond, attorneys, for CLE credit. And I'm sorry, Gail, please continue.
Rachel, I think we can round out this presentation today with your sort of lessons learned that you would want to share with folks looking to start a program similar to yours in their community.
It's a lot of work. You need staffing, you need money, you need PowerPoint presentations, you need training, you need landlords on board, you need the cooperation of somebody to get landlords to the table. So whether that's, you know, the landlord associations are really going to get on board and are going to push it with their members, or you need some type of legislative requirement that landlords participate, or you need a court that is supporting you and working with you. Because without that, you know, here in Philadelphia, we have a system that is very easy for landlords to file an eviction case and just move for eviction. So that's what the culture is, right? Like, it's not working with this tenant, I'm just going to evict. It's fast, it's cheap, you know, why not? So in order to change that culture, you really need something. And unfortunately, COVID is what gave us that something. So it will hopefully work out, and it will hopefully sort of change the culture enough that once it is no longer mandatory for landlords, we'll have been able to prove why it's so successful, and we'll be able to get the landlord associations on board, and we'll be able to get the courts on board. But yeah, it's a great idea, and it's a lot of work.
Excellent, excellent. Well, I want to thank all 3 of the panelists, as well as the Pennsylvania Legal Aid Network, for giving us a format to have this really great conversation. I think all of you are doing some really amazing work in your communities and really combating this crisis and doing it in the midst of a far greater crisis. So I want to thank each of you, as well as the attendees on the webinar today, for posing such really great and thoughtful questions. And everybody, please enjoy the rest of your day and the rest of your week. Thank you.
Thanks, everyone.